Thank you. So, our next presenter is Carly Ward. She's an attorney at Idaho Estate Planning. Carly Ward received her law degree from Concordia University School of Law and her undergraduate degree in political science from Brigham Young University in Idaho. While Carly has been an integral part of the Idaho estate planning since 2019, her passion for helping families make long-term estate plans, protect their assets, solve complicated care and estate problems, probate, and Medicaid is evident. She's received comprehensive training in Medicaid and continuing education in Idaho Estate Administration, sales of business to outsiders, and business law essentials. Carly is highly invested in her community. She has been recognized for her pro bono work, volunteer work on legislative reform, board membership for Healthcare Share Treasure Valley, is a member of Learn Idaho, and is a podcast guest on DIY wills and estate planning mistakes. She also spends her time in the community educating other professionals on Estate Planning 101 for realtors, Estate Planning 101, and Estate Planning Basics for social workers.
All right, Carly, do you want me to share your slides or would you like to share them in Drive? You're on mute.
I would love to drive if that's okay.
Great. It is perfect.
Okay, all right. Did that come through okay?
Yes, it looks great.
Okay, great. So, hi, thanks for having me on this morning. I am going to go through some basics of probate, let you guys know kind of what the process looks like, and how it works in the court system. So, um, yeah, feel free to stop me if you have any questions. Go ahead. I will try to keep an eye on the chat if there are some, so we can kind of go through those as we go. Okay, so probate. Probate is a legal proceeding that we go through in all 50 states, and it is the process by which we are able to appoint someone to sign on behalf of a deceased person. It also gives us the opportunity to do a couple of other things. So we get to appoint a personal representative. That's the person who gets to sign on behalf of someone who has passed. It also provides a forum for us to go through someone's will, make sure it is a valid will. If anyone wants to contest the will, this is the forum where they do that. If there are any instructions in the will that are illegal, this is where a judge gets to say, hey, we're not doing that particular thing today. And it also provides a way for the court system to enforce the things that were put in someone's will that are legal. It helps us transfer property after passing. And yeah, the biggest downside, it is very time consuming and it's very expensive, as most things in the court system are. So the other biggest downside here in Idaho, we value our privacy a lot. So everything that happens in the probate court is a matter of public record. So who has passed, who their heirs are, and sometimes what their assets are and what is getting passed on to their heirs is all a matter of public record. So a sort of savvy criminal would be able to find that information, maybe go after an heir that's just recently inherited a lot of money and prime scam target. So if there's a way to keep it out of court, I am all here for it. We'll go through a brief history of probate. Probate's kind of been around since the beginning of time. There has been some form of being able to pass down your assets from parent to child. I mean, we've got stories in the Bible like the prodigal son that go through some of the, issues and things that can surround that. Um, the Romans were the ones who brought us wills, and we got probate court in 1066 from the Normans. Um, Probably the part of probate that is most famous in pop culture kind of exists around this 17th and 18th century English law. So that's where we're going to get things like the main conflict for Pride and Prejudice. We're going to get Bridgerton. We're going to get a lot of stuff in the Gilded Age. All of those conflicts for most of those stories revolve around who's inheriting what and the inheritance laws that existed back then, which were definitely father to son or male heir to next male heir. So yeah, that kind of is the source of a lot of conflict for those stories. In America, we split from the being solely British, following British laws after the Revolution. We started to change those a little bit between the Revolution and the Civil War to allow women and to inherit. So wives weren't able to inherit from husbands, and daughters weren't able to inherit. We also had to change property law during then, so women could actually own property. So um, that was a fun change in the law. It allowed a lot of things to develop a lot more quickly. We also didn't have to worry about doing big searches for heirs. So current probate law, we draw both from English common law and Spanish community property law, especially out here in the West. And most of our probate code laws were developed in the 1960s. In Idaho, for the most part, we follow the Uniform Probate Code, which came out of the 1960s. I would say a majority of the states adopted the Uniform Probate Code and then just kind of tweaked little things, which is what we did as well. And then I think Knives Out is really fun. I reference Succession and Yellowstone a lot at work because both of those have to deal a lot with the same type of issues and families and friends dealing with those types of things. So there's a lot of pop culture in my world. All right, so who needs probate or who is going to run into probate? For the most part, everyone is going to see some sort of probate, or unless they actively avoid it. So probate is needed for any assets that don't have beneficiary designations. If you own real property or land, a house, anything like that, you are for sure going through probate. If you have over $100,000 in assets, you are going through probate. If we don't know who your heirs are, we're also going to go through probate. We have a couple of probate shortcuts here in Idaho. We've got some small estate things that we can deal with where you have less than $100,000 in assets and you don't have any property. We're going to take a look at some of those alternatives because they are faster, quicker, and cheaper and accomplish the same thing. And it's less paperwork on my end. So I always appreciate that. Okay, so the probate court process as a whole, it's got to take at least 6 months. Very rarely do I see a probate that takes 6 months because there's a lot of work to do. Yeah, it sucks. The longest one I've worked on is 5 years. That also involved going to 3 different states, and we had to probate 3 different deaths all at the same time. Um, it was a good time. I'll tell you about that one sometime. So there's 2 main types of probate, testate and intestate. And this just is determined by, do we have a will, or or do we not have a will? Are we just going by the Uniform Probate Code inheritance laws and just hoping for the best? We also have 2 different types of proceedings. So there's informal and formal. So there's like 4 different types of probate once you get through the testate, intestate, formal, informal. Informal means that it is a court process and we are submitting documents to the judge, but we don't necessarily appear in front of the judge. We don't have a formal hearing. We just kind of do everything via applications and affidavits and stuff like that. So we are able to, I love doing these. These are my favorite ones. If I could only choose one type of probate to do, very informal. We get to put everything together, send it off to the judge. Judge reviews it and says everything looks good. We're not foreseeing any big conflicts or issues, so let's go ahead. We always have the option, if there is an issue that arises, to make it a formal probate where we are able to get in front of a judge, we have a hearing. Luckily, most of those are done via Zoom like this, which is nice for me. And it's also nice for our clients because you don't have to pay me to drive to the courthouse, sit in the courthouse during a cattle call where we're running through 30 cases in an hour, to just do some formality stuff and then pay me to drive home. And I don't have to park at the Ada County Courthouse, which is such a struggle. So we do them via Zoom. They give us an opportunity to resolve any disputes that have come up with the will, or if we're not able to find the original will with like the actual wet signature, we also do a formal probate. So to validate this photocopy of a will that we have usually. So if anyone has a newer will, or if they have found the original will, they can bring it forward. And this is kind of their opportunity as well. So the judge is then going to review everything, review the application, review all of the documents we sent in and the will, and appoint a personal representative. Hopefully that person is listed in the will. If not, we go with, there's a whole hierarchy of who can be personal representative. Usually it's a spouse, and then it's a child or children. They all have equal footing. So sometimes if you don't have a will and you're like, yeah, great, my kids will just figure it out. If there's 4 kids, they all have an equal opportunity and say when it comes to being the personal representative. So that could be 4 people whose signatures you have to get and you have to coordinate with all the time. It's a big pain in the butt. And if they can't agree to let one sibling do it and sign off on that, then we've got to make sure everybody agrees all the time for everything, signs off on every transfer that happens. It is definitely not going to be done in 6 months. After the judge reviews the will, appoints a personal representative, the personal representative is given a official decree from the judge that says they're the personal representative. It is stamped. And then they're able to go forward and start taking care of business on behalf of the decedent. First thing they've got to do, well, we like to do this first because of the time constraints, is they need to publish a notice to creditors, not in the paper. And this has to run for a certain amount of time. And then we have to wait 4 months. So this is where most of the 6 months is eaten up. But we have to wait to see if there are any creditors out there that we didn't know of. this is their opportunity to come forward. So the personal representative then has to make sure all of those valid debts are paid. They've got to make sure last taxes are filed with the IRS. Um, so unless you die in a very specific window in the year, this is the thing that pushes things out from 6 months for the most part. Is we then have to wait till the next tax cycle. We have to wait until we can get documentation for the next year, so that we are ready to go for those tax filings. And we usually have to wait till the next January until we can get a hold of those. Then we've got to finish grabbing all the assets, putting them in this big pot, making sure that they've been liquidated, the house has been sold, whatever's going to happen. And then we have to distribute the assets according to the will. That is, that's the part that everybody likes, is getting the money. But this is also a giant pain. Most of our personal representatives are trying to make sure it is tax advantageous for their siblings or whoever's inheriting. So sometimes the assets are being moved from an IRA and being rolled over to the heirs IRA. So there's lots of paperwork and just trying to make sure everything's equal and everything's going the way it should go, and sending checks to people that, do they live there? Do they not live there? Are they unhoused? What's going on? So it's not a job I envy at all, is being a personal representative of someone's estate. At some point, I am probably going to have to do it, but yeah,
So question for you,
I'm not
Carly.
looking forward to it. Yeah.
On the 4 months, the notification for creditors, how does that process work, and how often is there a lot of activity there? Has that become kind of an archaic thing, or is there a lot that happens there?
Sure. You would think it would have become archaic, but with the advent of technology, we still have to publish in the paper of record, and all of those publications are online now. So they're both in the paper and online, and there are several bots that will go through and comb through those. So the companies we see things from the most are credit card companies and phone companies. They have those bots that are going to crawl through those papers of record and see if they can match anything up
Or
as
maybe
far as
even
a
an
decedent.
increase. Yeah, there might even be an increase in
Yes.
that activity.
Yeah.
Interesting.
So, yeah, there has been a little bit of an increase, believe it or not. So, we've, yeah, those happen a lot. A lot of medical bills, stuff like that come during that time. So you would think with, actual physical papers going the way of the dodo, that there would be less, but actually the technology increase on the other side has increased it. So it'll be really interesting. I don't know what that publication requirement looks like going forward. I don't know what it looks like in the next 10 years with papers phasing out. But I'm sure there will be some sort of notice requirement that goes out, but I don't know what it looks like right now. But no, that was a good question. Okay, there is some wrap up that happens afterwards, but most of it depends on the type of probate that we're doing and the assets that we're dealing with. But for the most part, there is a sign off that happens with those checks. You have to sign, yes, I got the check. Yes, it was everything I was supposed to get from the estate. I don't hold the personal representative liable for anything else. Stuff like that, that all gets filed with the court to wrap things up. But that's not very exciting, so I didn't include it in here. So we talked a lot about wills. So what happens if your client doesn't have a will, which most don't? I'm just going to throw it out there. It's a really absurd stat that like 30% or less of the American public has a will of any sort or any sort of estate planning, which is not great. We have room for improvement there. So if your client doesn't have a will, the state has one for them. Like I said, we put together our probate code in the 1960s. So that is what we based it off of. And we based it off of a very nuclear family in the 1960s. So we didn't account for divorce. We assumed everyone was going to be together in their marriage forever, and we were going to treat all the kids equally, and that the kids were not going to have any problems, and there weren't going to be any stepkids, and it was all going to be great, lovely, one big happy family, which is the best we can do even now. We have not changed it because what do we do? If you've got a great answer for that, let me know. But yeah, it's kind of a one size fits all, and it is very problematic. So back then, divorce was a lot lower. Women couldn't get credit cards. They couldn't open a bank account without their husband. Totally different time. The financial freedom kept women in those marriages, and this was a thing that worked. Now it does not. So if there is a divorce, if there is a second marriage after a death or something like that, we have these very blended families, and families look very different. And we've got kids that the one I see a lot is we've got kids with gambling problems and we've got kids with drug issues. And the last thing a family member wants to do is to give them the money to kill themselves. And I know that sounds hard and really harsh, but that is essentially what they're doing. So they want to do something to protect that person, and the best thing for them is to not give them money. So we've got to come up with something better. We've got to be a little more proactive in what we're doing instead of just not doing anything and hoping for the best. Another one we see a lot with people who don't have a will is they are going to um, disenfranchise their biological children if they have remarried. So if you've remarried and you've got community property with that new spouse, they get all of that community property plus half of your property that was separate. So they're getting 75% of your assets, and your biological children are getting 25%. But guess what happens when second spouse dies? It does not go to your children. It goes to their other children. So biological children kind of get the short end of the stick in this situation if there is no proactive planning. Okay, so most of you are somewhere in either the healthcare space or the social service space, or you're working with seniors, but you're not necessarily in the legal or financial world. There might be a couple of you that are, but for the most part, you're kind of in that social service medical space. So I wanted to give you guys some thoughts on how you can help your clients. Okay, number one is encourage them to do their estate planning before they become incapacitated or die. I've got two ends of this. We talked about the will part. Like, yes, let's make sure things are going to who you want them to go to when you want them to go to them. The other thing is this is our opportunity to also avoid probate. We talked about probate. It doesn't sound like a good time, but we can take care of things and we can put things in place so that we don't have to go through that probate at all. Also, incapacity. So most of us are not going to go from well one day to deceased. We're not going to do that. The odds are not in our favor. There is going to be some sort of a decline that happens, and we need to be prepared for that. And that may need to include financial preparation, and it may need to include some powers of attorney, some healthcare powers of attorney, and give us some people that can help us make decisions. So yes, please do your estate planning before you go. Please do it before you become incapacitated. The more proactive you are, the more opportunities we have, the more tools we have available to us. And the next thing is you can clear up some misconceptions about estate planning. These are not legal advice, so you are welcome to give them. The first one I hear a lot is, if I do my will, I'm going to die. You're going at some point, you're going to pass. Death has got a pretty good track record. I think they're batting 1,000 right now. So um, I don't have the power to cause you to die because you signed your will. If I did have that power, I'd be doing something else with it, but not causing you to pass because you did your will. The next one is trusts are only for the super wealthy. That is false. I don't see anyone super wealthy in my office ever. So you don't need to be rich for a trust to be an effective planning tool. Um, I would say the bare minimum is, do you want to take care of your assets? Do you want to avoid probate? Do you have a house or any sort of property? Like, if yes to any of those, like, we need to look at a trust. It may not be the right thing for you, but we need to sit down and work through some questions. I wish, yes. I just got one that we have a trust and we are not super wealthy. Most people, like, listen, no one's super wealthy here in Idaho. Like, maybe a couple of us are, but it's all good. Um, the one that I wish was true is that there is no will reading. I'm sorry to say, like, there's that whole thing where you're going to go to the attorney's office, they're going to read the will, there's going to be like some big shocking moment that somebody got cut out, or your mom's going to make you, like, I don't know, take this like journey of self-discovery. No, there's no will reading. Although, if anyone wants to like start a will reading business with me, we can get like a big wingback chair. We can rent an office. I know they're great theater. They're a great story device, and that's why I think I should just go in and, like, we'll travel around and we'll read your will to your family. So I wish that'd be so fun. Whoops. The next one is, the attorney is going to judge my family and my choices. I'm not. Um, I don't care. Your family's your family, and you're the one that's going to have to deal with the choices and the consequences. And I don't care about how we got here. I just want to know, how can I help you do the things that you want to do? So my goal is to put together a structure that accomplishes your goals. And I want to do it simply and most inexpensively. Um, but I'm not judging you or your kids. It's not my place to judge. I don't have kids. I don't know what it takes to, like, make sure your kids grow into good adults. Yeah, yes, I will, honey. Um, so yeah, I am not judging you. My job is to just make sure that A, you're not being taken advantage of by anybody, and B, we can accomplish what you want to accomplish. Number two, the next biggest way you can help your clients is, please don't play a lawyer on TV or in real life. Unless you go to law school, then great. So here's the biggest thing. Don't download something off the internet for a client and say, hey, great, you should do this. Even providing these documents is the unauthorized practice of law. And this case is from 1959, was the first time this case was tried. There was a second case, very similar thing, 2002. So this is not a new thing that, people have been providing forms to other people. Don't do it. It is not a good time. But unauthorized practice of law also includes any sort of legal advice and counsel, or the preparation of documents, even if they're not like currently in court or going to be in court, anything that could potentially be legal advice, counsel, or documents that could be in court need to be prepared by a lawyer, or else it is unauthorized practice of law. Um, if you do, here are the things that could happen. If you get caught, the unauthorized practice of law comes with up to a $500 fine or 6 months in jail or both. The part that is really probably going to hurt the most is professional and personal liability. Your malpractice insurance, A, does not cover this, and B, it's not lawyer malpractice insurance. So if you get sued for these documents, um, the likelihood that your professional liability insurance covers this is zero. So that's going to be a very hefty bill. There are unintended tax consequences for clients if you provide them with the wrong document, or if they move money in a certain way and they did not clear it, run it by an attorney, run it by the CPA, run it by the financial planner. We are also not the end all be all in these situations. We run everything by the CPA. We run it by the financial planner. Like we have to, estate planning is like very much a team sport. Improperly drafted documents and faulty financial analysis will disqualify your clients from the very programs they are trying to qualify for. I've seen a lot of people doing Medicaid planning, and this is very much going to be something that can get you into trouble. If there's any sort of faulty financial analysis or putting together documents or moving money into trust that you created and vice versa, if those are not done by a lawyer in a very specific way, health and welfare is going to come after you. And then I also put in that you might unintentionally disinherit someone. I'm currently working on a probate that of a will that was provided by a medical professional slash social service member of our community. And a couple of things. First off, they misspelled will on the front page, and that is immediately what my eyes went to. Second off, it is going to disinherit their biological children. And I don't know if that was their original intention, but the way this will is written up, it disinherits their biological children unintentionally. It doesn't actively say, I'm disinheriting these people, but the way it is structured is disinheriting their biological children in favor of new spouse and new spouse's children. So I'm hoping new spouse runs through all this money and it's all gone by the end of new spouse's life, so that no one is having to explain to these biological children why they didn't inherit anything from their dad. So very much a problem, and we can't tell the intentions of the person who made the will because somebody put together this will for them, didn't spell check, which is baffling, and then just handed it to him and said, sign this. So yeah, problems there. I'm hoping it doesn't become an issue, but it very much could here in a couple of days. I don't know. We'll find out when their kids find out that there's a probate. So yeah, please don't practice law without a license. It's not a good time. Nope. Okay, some really good legal resources to keep on hand. First of all, there is a great community of estate planning attorneys here in the Valley. There's some people who are really good with the disability end of law that we have some great ones in the Valley. So I'm really excited about that. And we're always willing to at least help you find the right type of attorney for whatever the issue is. I went to school here in Boise, so all of a big chunk of the attorneys that I went to school with are all still here in the Valley. So we have a really good network. If I don't know the person to send you to, I usually ask them, hey, who have you got that's done a really good job with the one I just had to ask was medical malpractice. So who have you got that does med mal that you really like? And so we're able to kind of refer to each other and send good people to other good people. So other legal resources. Legal aid is great. They've got some great things on predatory lending, on housing, and guardianships.
Can you go into revocable and non-revocable trust just really quickly?
Oh,
There was
yes,
a
and
question
I
in
just
the
noticed the
chat on
time.
that.
So yeah, revocable versus irrevocable trust. So revocable trust, it is very self-explanatory. Revocable trust can be changed, updated, amended, whatever you want to do to them while you are alive and you are cognitively able to do that. Um, Revocable trust can become irrevocable upon your passing or upon a spouse's passing. This just means that without going to court and doing a whole big thing, these trusts can't be changed. So irrevocable trust can't be modified or changed. There are like we could go to court and have to do a whole big thing, but outside of that, we can't change them. So this is why they're a really good tool for some Medicaid planning is because they're irrevocable, so we can't make changes and, pull some fast, shady nonsense without health and welfare knowing. And those are also usually handled by another party. So if I was needing Medicaid planning, I would not be the trustee of my trust. I would be the person contributing money to the trust, but I am benefiting from the trust, but I would not have control over the money, which is the one of the things that makes it possible for us to do some smooth moves to help plan for Medicaid. Um, but that is the biggest change, is the biggest difference. Revocable ones are revocable, changeable, we can move them around. Irrevocable ones are not. Those are pretty set in stone, but those are a really great tool by Sarah, uh, to be able to do some really creative planning. So, any last questions before I let you guys go?